All right. On behalf of Giuliano, let me welcome you to this talk co-hosted by the Asian Institute of International Financial Law and the Center for Private Law. This is part of IFL's Financial Law and Regulation seminars. I am very, very pleased and honored to introduce our speaker, Dora Neo. Dora is an associate professor of law at the Faculty of Law at National University of Singapore and was the founding director of the faculty's Center for Banking and Finance Law and was my teacher, though unfortunately not on secured transactions. I believe I took international business transactions with Dora. Dora will be speaking to us about security over digital assets, issues in private law. So without further ado, over to you, Dora.
Thank you very much, Calvin. Good afternoon. I am delighted to be here with you today. Thank you all so much for coming. I would like to express a special thanks to Professor Giuliano Castellano for inviting me to be a visiting fellow at the Asian Institute for International Financial Law, that's the AIIFL, and also to thank the AIIFL and Hong Kong U's Private Law Center for co-hosting this seminar. I'm grateful to Professor Kelvin Low for agreeing to chair this seminar. I feel very privileged to be visiting Hong Kong U at this particular time. In addition to Professor Giuliano and Professor Low, who are experts in the law of secure transactions and private law and digital assets, we also have some distinguished experts with us, in particular Professor Michael Bridge, who will speak on intangible assets and personal property in CPC's first distinguished public lecture on Monday, and also Dr. Adam Waldom, who spoke on the limits of codified secure transaction statutes at the seminar yesterday. So this is a series of happy coincidences for me. For today's presentation, I would like to share some thoughts on the private law aspects of taking security over digital assets. Private law aspects meaning in contrast to the public law or to the regulatory aspects. So I will first look at the question of whether digital assets are property, because this is important for taking security. If they do not amount to property, then there's no point talking about taking security over digital assets. And I will apply the concepts of secure transactions law to electronic transferable records, that is like, for example, trade documents, and then to crypto assets, and then I will attempt to make some conclusion. So the first question that I have to consider is whether digital assets are property. And this term, digital assets, was actually inspired by the UK Law Commission project on digital assets, which led to the Property Digital Assets Act, and also the UNIDROIT Principles on Digital Assets in 2023. So in the UK Law Commission Digital Assets final report, the way that digital assets was defined is any assets that is, that is represented digitally or electronically. And in the Law Commission report, they say that this includes digital files, digital records, email accounts, domain names, in-game digital assets, digital carbon credits, crypto tokens, and NFC. So the Law Commission report highlighted that not all types of digital assets are capable of being things to which personal property rights can relate. So in this context, in fact, it might seem to be more accurate to just refer to them as digital things rather than digital assets. And in fact, the title of the statute itself is Property, Digital Assets, etc. Act, which you will see. So in other words, it's thinking that it's not just referring to digital assets, but other digital things as well. The UNIDROIT Principles on Digital Assets defines digital asset as an electronic record which is capable of being subject to control. So the UNIDROIT definition is, in a way, it is narrower than the Law Commission's definition. So, question, are digital assets property? And the answer is that they can be. And I would look first at the UK Property, Digital Assets, etc. Act 2025. In section 1, it says, a thing, including a thing that is digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither a thing in possession or a thing in action. And the UNIDROIT Principles on digital assets states that a digital asset can be the subject of proprietary rights. So we know that digital assets can be property, but we do not know exactly, based on these statutes, when they will be property as such, or what might distinguish what we might call a third category right from a thing in action or a thing in possession. And these are questions which would seem to be left to the common law. So I'm going to take us through the different thinking on digital assets. And next, I want to look at some academic views on whether digital assets are property. And there is a lot of scholarly writing on this, much more than I can summarize or tell you about today. So what I've done is I've selected a few quotes, which might give us a range of views in this particular area. So the first idea, just to quote Professor Roy Good, writing quite recently in the LQR, a very simple idea that subject to statute, property is anything of realizable commercial value. And this seems to be something that might be quite easy to satisfy. Professor Calvin Lowe, in his article Law, Innovation, and in article Bitcoins and other crypto assets as property, he says that property rights over Bitcoins may well represent a truly unique and novel form of property altogether. This view is generally well supported by other academic writings, but Professor Robert Stevens holds a different view. In his article, Crypto is Not Property. This is largely written in response to Professor Roy Good's article. He says, well, crypto is not property. Nobody has ever identified any right in relation to crypto, nor how it would be vindicated. Therefore, it is not property. Professor Stevens, though, acknowledges that its statute could well provide for recognition of property rights in relation to crypto assets, just like the way it has created, for example, patents, copyrights, and other trademarks. But then he questions whether or not it would be useful to do so. Let me move on now to talk about some cases which deal with the question whether digital assets are property. And in fact, there are many of these cases which might deal with this question obliquely, but I will just mention a few just to give you a taste and some of the most authoritative judgments. In the UK, we have the case of AA against persons unknown. And in this case here, the court considered the question whether Bitcoin is property capable of being subject to a proprietary injunction. And the judge held that Bitcoin actually met the criteria which are set out in the National Provincial Bank against Ainsworth case. This is a 1965 case, as being definable, identifiable by third parties, capable in their nature of being of assumption by third parties, and having some degree of permanence. And I'll just set out this summary in a later slide. In another case, the allure against persons unknown and others, the claimant was fraudulently induced to transfer Tether to the defendant, one of the defendants. And after a series of transfers, this cryptocurrency was actually withdrawn from a licensed crypto exchange in Thailand. And the questions before the court was whether Bitcoin was unjust, whether or not the crypto exchange was unjustly enriched by receiving the virtual assets, and whether the crypto exchange was holding virtual currency on constructive trust for the claimant. And the court held in this case here that Tether was a form of property and it was an asset satisfying the tests of National Provincial Bank and Ainsworth. So the idea is that the cryptocurrency could be held on constructive trust, but the claim failed because it was not made out. Another case that was recently decided is the case of R against Lakeman, just decided earlier this year. And the question here related to the theft of gold pieces in a computer game. And the court decided that these gold pieces constituted property. The court stressed that the test of property in the Theft Act is not the same as under private law, but nevertheless, the court went through all the different questions or the different discussion in the Law Commission's consultation paper. And I do believe that perhaps even in private law, the result would have been the same. Let me move on to Singapore. In Singapore, we have the case of CLM against CLN. And in this particular case, it concerned digital currency, which consisted of Bitcoin and Ethereum. And this digital currency was stolen. So the plaintiff sought a proprietary injunction prohibiting the defendant from dealing with the stolen assets and also a worldwide freezing injunction. And the court decided that these cryptocurrencies satisfied the classic test of a property right in NPB against Ainsworth. So the interlocutory injunction was granted, showing that there was a serious issue to be tried and on deciding whether crypto assets could be held on trust. The case of Bybit FinTech against Ho Kai Sin consisted of a situation where the payroll clerk had wrongly transferred Tether and currency to her own accounts, and the plaintiff or the claimant applied for a worldwide freezing and proprietary injunction and was successful in seeking summary judgment for a constructive trust to be imposed. So the High Court in Singapore held that the assets were property, satisfying the NPB against Ainsworth test. And quite significantly, the court in this case expressed the view that crypto assets are things in action. Earlier Singapore cases had not expressed a view as to how crypto assets should be classified. So the judge mentioned that this is things in action, even though crypto assets could not be classified as things in action, because this category of property originated, just because this category of property originated in rights being enforceable, in court. That doesn't mean that it had to satisfy this test in order to be a thing in action. He pointed out that over time, the category of a thing in action was expanded and the category of things in action was broad and flexible and not closed, and therefore concluded that the holder of the crypto asset had in principle a right of property, which was recognizable by the common law. And this crypto asset was being capable of being held on trust. In Hong Kong, you have the case of Gatecoin Limited. Gatecoin was wound up, and following Gatecoin, it had operated a cryptocurrency exchange platform. And after it was wound up, the liquidators applied to court for a ruling about the characterization of cryptocurrencies. I found it interesting that this exchange actually helped the trading of more than 45 types of cryptocurrencies. Of course, we are familiar with the most famous types, but there really are many other types of cryptocurrency. And the question was whether or not these could be held on trust. And the court expressed the view that although a crypto asset might not be a thing in action, but that doesn't mean that they could not be subject to property rights. So this is interesting because the approach is a little bit different from the one taken in the Singapore High Court. In the High Court case in Singapore, they stated that the cryptocurrency was a thing in action, whereas in Hong Kong, the judge is saying that it's not a thing in action, but that doesn't mean that it can't be subject to property rights. In a way, this is very in line with the UK Property Digital Assets Act, the position taken there in relation to a third category of things. Another thing that this case showed me, which is something that I will just say in passing, is that the conditions of each exchange and how each exchange operates. For example, this exchange maintained different wallets with different functions, and it transferred from one wallet to the other for different purposes. So the way that the exchange work, in fact, will determine the control of the cryptocurrency and the rights of the parties. And this in turn could affect whether certain cryptocurrencies were held on trust for customers of the exchange. And I think that the decision here was that they were not. So let me move on the premise that a digital asset is a thing, which is a proper object of a personal property right, and now look at taking security over digital assets. Perhaps before we go on, I realize that I have another slide which I should talk about. And this is, as I said earlier, I will set out the classic test, which all the cases that I've talked about apply, the one in NPB against Ainsworth, and I'm just setting it out here for you to look at, that in order for an interest to be admitted into the category of property, it must be definable, it must be identified by third parties, it must be capable in its nature of assumption by third parties, and it must have some degree of permanence or stability. I must say that in the cases that I've talked about, in fact, there wasn't very much discussion about how the crypto assets actually fitted within these tests, but nevertheless, the courts in all the cases were satisfied that the test of what is a property interest was actually satisfied. So I think we can take them at face value in relation to this. The other concept that I feel I should introduce is the one of rivalrousness. And this concept, in fact, was introduced by the UK Law Commission in its Digital Assets Final Report. And they explained that a thing is rivalrous if the consumption of the thing by a person or a specific group of person necessarily prejudice the use or consumption of the thing by one or more other purposes. So if a thing is rivalrous, then the holding of the thing by one person necessarily prevents another person from holding it at the same time. And so, for example, a holder cannot double spend their Bitcoin. In their response to the UK Law Commission consultation, Clifford Chance LLP expressed the view that the concept of rivalrousness can be used to separate pure information from crypto assets. They said, for example, that the information in databases and in photographs could be infinitely duplicated and therefore is not rivalrous. This concept of rivalrousness was endorsed by the UK Court of Appeal in the Tulip Trading Against Bitcoin case, where the court mentioned just in passing that a crypto asset such as Bitcoin is property. So let me now move on to taking security over digital assets. On the assumption that the digital asset that we're concerned about is a proper object of property rights, what about taking security over this asset? And we have to remember the aims of taking security in order for a creditor to be willing to take a particular asset as collateral. It must make commercial sense to them. So the asset must have some value, at least sufficient to support the debt, and the creditor's legal rights must be clear. creditor is really seeking is a proprietary interest in the debtor's asset that it can realize in order to repay the loan if the debtor refuses to pay or if the debtor goes insolvent. And having a proprietary interest is definitely preferable to having just a personal obligation of an insolvent debtor and having to share pari passu with the other unsecured creditors. So to take security successfully, a creditor would want to ensure that the security is validly created, that it is perfected so that it is valid against third parties, and that it can be effectively enforced upon the debtor's default. While a lot of excitement surrounding digital assets is understandably focused on crypto assets, the class of digital assets is much broader than that. And I will discuss two contrasting types of digital assets. First, electronic assets or electronic records that represent physical documents, for example, electronic bills of lading, electronic promissory notes, electronic negotiable instruments and bills of exchange. And next, also, the exciting bit of crypto assets, which only exist in the digital world. So let me first talk about the first type of asset, which is electronic transferable records. In the UK, this is limited to electronic trade documents. So I'll just put / electronic trade documents that might be more relatable than electronic transferable records. There has been growing interest globally to create a legal framework to recognize digital versions of certain types of paper documents. And the most significant development in this area was the UNCITRAL Model Law of Electronic Transferable Records, which was adopted by UNCITRAL in 2017. And it enables electronic transferable records to have the same legal effect as physical transferable documents. It puts forward the key principles of non-discrimination against the use of electronic means, of functional equivalence, and of technological neutrality. Since then, 13 jurisdictions have passed legislation either based on or influenced by the Model Law of Electronic Transferable Records. I'll just call it MELITA for short. Singapore was one of the first adopters of this, and it adopted MELITA principles by amendments to the Electronic Transactions Act. In the UK passed the Electronic Trade Documents Act in 2023. China revised its maritime code to incorporate MELITA principles for bills of lading in 2025. And in fact, in Hong Kong now, there is an ongoing industry consultation on the adoption of MELITA in order to make, by way of an amendment to the Electronic Transactions Ordinance in Hong Kong. Given that this is something of current interest in Hong Kong, I will spend a little bit of time explaining the key features of this particular MELITA approach. This area of law concerns the electronic versions of paper documents that fit the definition of transferable documents. What are transferable documents? These are paper-based documents that entitle the holder to claim the performance of the obligation indicated within it, and that allow the transfer of the claim to that performance by transferring possession of the document. So examples I have already mentioned before, for example, a bill of exchange would be a transferable document. So would a bill of lading be a transferable document. The way that Singapore has done this statutory amendment is that it has adopted the language of the electronic, it has adopted the language of the MELITA almost, well, quite faithfully, apart from certain changes that it needed to do to be consistent with the rest of the Electronic Transactions Act. In the UK, it uses a different language. The UK Electronic Trade Documents Act uses the terminology of paper trade documents, and it defines a paper trade document as a document that is of a type commonly used in connection with the trade or transport of goods or financing such trade and transport. And possession of the document is required before the person can claim performance of that particular obligation. So the UK statute gives 8 examples of electronic trade documents, including a bill of exchange, a promissory note, bill of lading, a warehouse receipt. The UNCITRAL model law doesn't give any examples, and the Singapore statute gives just 3 examples: a bill of exchange, a promissory note, and a bill of lading. The UK statute makes it clear that electronic documents can be possessed, just like physical documents. So what is an electronic transferable record? In order for an electronic transferable record to be equivalent to a paper transferable document, the electronic transferable record must contain the information that would be required to be contained in the paper transferable document. In addition, a reliable method must be used to ensure singularity, control, and integrity. Singularity in the sense that the electronic record must be identified as the electronic transferable record that is in question. Control in the sense that the electronic record must be capable of being subject to control from the moment of its creation until it ceases to have any effect of validity. And this is important because control is equivalent to possession. And integrity in the sense that the information that is contained in the electronic transferable record must have remained complete and unaltered from the time of creation until it ceases to have any effect. There are certain provisions for electronic equivalence of the concepts from the paper world, and this is dealt with in Articles 8 to 11 of Melita. Article 8 explains what is the equivalent of writing. The information must be accessible so as to be usable for subsequent reference. What is the equivalent of a signature? And in order for a digital record to have the equivalence, a reliable method must be used to identify the person that is setting out the signature and to indicate the person's intention in relation to the information contained in the electronic transferable record. The equivalence of possession. In order for a functional equivalence of possession to be found, a reliable method must be used to establish exclusive control of the electronic transferable record by a person, and also to identify that person as the person in control. And transfer of possession is done by transfer of the control. So the interesting thing is control is not defined by Melita, and it's also not defined in the other statutes. We might have noticed by now that this idea of a reliable method is a recurring idea. It is required to ensure that an electronic record satisfies the requirements of singularity, control, and integrity. It is required to establish the identity and the intention of a person that is signing a document digitally. It is also required to establish exclusive control and the identity of the person in control when determining possession of a digital transferable document. So what is the standard of reliability that is required? And this is set out in Melita in Article 12. This method must be as reliable as appropriate for fulfilling the function for which the method is used. And this is seen in the light of all the relevant circumstances. So Melita sets out some circumstances. This is not exhaustive. For example, what are the rules of the system? Is there assurance of data integrity? Is there the ability to prevent unauthorized access and use? What is the regularity and extent of independent audit? the security of the hardware and software, and the existence of any declaration by a supervisory body regarding the reliability of the system, any applicable industry standard. An alternative way of establishing reliability would be that if this is proven, in fact, to have fulfilled the function. And in Singapore, I want to talk about the accreditation procedure, but I also would highlight that it is this standard of reliability that is likely to lead to the most, I think, litigation or arguments in relation to Melita, because everything depends on whether a standard of reliable standard has been used. And if it hasn't been used, then in fact, there wouldn't be functional equivalence. And this is where the Singapore approach might be significant, in the sense that Singapore sets out the possibility to have an accreditation procedure. And under the Singapore statute, an electronic record that is issued or stored by a registered or accredited provider is presumed to be reliable until the contrary is proven. So there is no need to prove a reliable method if this is not actually challenged. So I would highlight that Melita is an enabling law. It doesn't change the existing law. The substantive law that applies to the paper documents will equally apply to the electronic transferable record. It is interesting that the Law Commission in their digital assets report state the proper categorization of electronic trade documents as being things in possession. And they explain that treating electronic trade documents as possessible things allows them to be plugged into an existing legal framework in respect of a limited category of documents that already enjoy a special status in law. So this makes it easy for us to talk about security over electronic transferable records, in the sense that the law of pledges, which is applicable to paper transferable documents, would be equally applicable to the law of electronic transferable records. So in other words, you could have the way that we would give security over a paper transferable document would be by way of pledge. And the pledge is done by handing over possession of the document. Since a paper electronic record, like a bill of lading, for example, is representative of the goods, if we pledge a bill of lading, a paper bill of lading, that's equivalent to a pledge of the goods. And brought over to the digital sphere, if control is given of an electronic bill of lading, then under Melita, this is going to be proper security. This is going to be proper security that is given over the electronic bill of lading. What about perfection of the security? The very act that creates the pledge, the passing of possession, is also the same act that perfects the security. So there is no need for any further registration. Enforcement of a pledge is also easy, in the sense that the common law allows a pledgee to actually sell the goods in the event of default. And this would be easy because in the paper pledge, in the pledge of a paper document, the pledgee would be in possession of the item. And in the case of an electronic document, they would be in control of the document. So one idea I would leave with Melita is the question of how new laws relating to transferable documents will be treated. So for example, there has been growing interest in the law of warehouse receipts. And in some countries, the law of warehouse receipts is not well developed. So what if in a country like Singapore, there is in fact an electronic warehouse receipt? What would be its situation? Since a warehouse receipt in Singapore is not a document of title, therefore, passing over possession of the warehouse receipt is not going to allow it to be transferred. And in order to satisfy the full benefits of a new warehouse receipt law, new laws will have to be promulgated. And the question is, how will the new laws be done? Will it be done by having just a law for paper documents and relying on MLETR to make it such that it also applies to digital documents? Or would it be such that digital and paper documents, warehouse receipts, are actually considered in the same statute. Let me move on to security over crypto assets. Crypto assets potentially encompass a range of arrangements, structures, and technologies, and generally speaking, they operate based on digital ledger technology. So they include famous crypto assets or cryptocurrencies such as Bitcoin and Ethereum, which operate on their own blockchain. Then there are crypto tokens, which do not have their own blockchain, but are built on existing established blockchains. These tokens might include stable coins, which are pegged to currency. They might include utility tokens, and they might include NFTs, that is non-fungible tokens used for unique objects. Blockchains can be permissionless, that is for open access. They can be permissioned. And the owner of the crypto asset could control it directly using a private key, which he stores in a digital wallet, or they could place it with a custodian under a centralized exchange. The terms and conditions of cryptocurrencies would vary, just like the practical arrangements would. And then there are forms of digital money that do not use the distributed ledger technology. For example, CBDCs that might be issued under centralized ledgers, and there might be also alternative technologies for issuing cryptocurrencies. So the point of this is to highlight that the digital world is vast. It is difficult to generalize. Even within one class of assets, crypto assets, there are many different variations. When the UK Law Commission wrote its digital assets report, it focused only on one type of a digital asset, and that is crypto tokens. They explained that most collateral arrangements developed in the digital world actually concern crypto tokens. So let me talk about security over crypto tokens. And in fact, this might not be very different from taking security over other types of assets. There are 4 types of security interests in the common law: pledges, liens, mortgages, and charges. And as crypto assets are not possessory items, then we're really talking about mortgages and charges. And to create a mortgage, the token must be transferred to the creditor. This could mean transferring the asset from the debtor's digital wallet to the creditor's digital wallet, with the understanding that the asset will be transferred back to the borrower upon repayment of the loan. Or if the token is held in a central exchange, then arrangements must be made with the exchange for this to be done. In the case of a charge, the asset is not actually transferred, but it is earmarked to be used in case the debtor defaults on the loan. As far as the charge is concerned, the charge could be a fixed charge or a floating charge. For a fixed charge, we would have to ensure that the debtor is not able to deal with the crypto asset, whereas in the floating charge, the debtor may be able to deal with such assets. I don't have much time.
A bit.
So I want to talk about perfection of a security interest in crypto token. And this is where I feel that, there is the most urgent need for legislation to be done in order to develop the law. So before a security interest can be perfected, before a security interest can be made to apply to third parties, it must first be perfected. If it's not perfected, it would not be enforceable against a liquidator of a company or other creditors. And the rationale for this is so that third parties who want to give security are able to find out whether the asset has already been charged or mortgaged. So in this way, the creditor would not be misled by the appearance of false wealth. In a possessory security, this is usually done by giving public notice. And when security is given by a company, then you would have to register a company charge. And the approach in Singapore, which is very similar to the one in Hong Kong, is that there is a list of registrable charges under the respective company's legislation. So there is a finite list of registrable charges. There are 10 items in each of our statutes, though not exactly the same. And the point is that if the asset appears on the list, it has to be registered. If it doesn't appear on the list, then it doesn't have to be registered. And unsurprisingly, of course, crypto tokens are not on the list because it's a new form of asset. So based on the list as it is, it's not actually registrable. And it would therefore seem that, you know, the sensible thing to do might be, if we feel that a security over a crypto token should be registered, would be to actually modify this particular list. But I don't think that that is going to happen because this is actually not a new problem. This issue of a finite list being very undesirable has already been there. So for example, if we think about bank accounts or if we think about company securities, these are very common assets, but nevertheless, they do not have to be registered under the Companies Act. So although in Singapore and Hong Kong, we actually base our laws on the English laws, but the approach in the UK after the Companies Act amendment is actually now quite different, and all charges must be registered unless excluded. And the English Law Commission spent a long time talking about whether or not crypto assets would fall under FCAS. This is something that was actually instituted by the EU Financial Collateral Directive, where EU countries were obliged not to impose restrictions that would invalidate certain financial agreements over financial collateral. So the question here is whether or not a security over a crypto token might fall under FCA. And that is not clear because it only applies to financial instruments, cash and credit. And the question is a crypto token, financial instruments, cash and credit? And also, in order for FCA to apply, the financial collateral must be in the possession or control of the collateral taker. So this is a question, and we do not know, we're not clear whether or not a crypto token would be seen to be in the possession of the collateral taker. So the position we have is that in Singapore and Hong Kong, crypto assets don't have to be registered under the Companies Act. In the UK, although all charges must be registered, but the question is, are they excluded under FCA? The other thing I should have mentioned is that if you have a floating charge over a crypto asset, then it is registrable in Singapore as well as in Hong Kong. But the question is whether or not the parties in the crypto transaction would be comfortable with giving a floating charge over crypto assets, because this allows the charger to actually deal with the asset. So I would just mention an alternative approach that has been discussed a lot. And this is the idea of perfection by control instead of perfection by registration. So in order, one of the problems with this idea of perfection by control would be, what would constitute control in the case of a digital asset? And the other question might be whether or not this control that we have over a digital asset, would it be something that it's prominent enough to be observable by third parties so that third parties can know that there is a proprietary interest that has been created. So if we wanted to amend the law, this could be a possible approach. I've done that. So let me just say something very briefly about enforcement. Usually, when you have a security interest, the rights of enforcement would be provided for in the documentation or in the case of, or in the law. And so, for example, the creditor may be able to take control of the asset and then to sell it. And in fact, there might even be a smart contract arrangement for automatic enforcement to take place. I should highlight that if court enforcement is needed, then the signs from Singapore appear to be that the courts would be very cooperative, because in fact our rules of court have been amended to recognize cryptocurrency as a form of property for enforcement. And even though the rules themselves do not say what procedure should be used, but in the case of Bybit against FinTech, in fact, the court showed itself very willing to extend existing enforcement procedures for non-crypto assets also to cryptocurrency. So a conclusion, the confirmation of digital assets being the object of property is a positive development from the point of view of secure transactions, because we want as many types of personal property as possible to be possibly subject to security rights. For electronic transferable records, UNIDROIT principles are efficient and they allow us to adapt long-established legal principles in the physical world to the digital sphere. And there are a few challenges. I already mentioned the question, for example, of a reliable method. As far as crypto assets are concerned, even though some of the ideas, in fact, many of the ideas in relation to taking security over personal property can be applied to crypto, but policy decisions must be made in relation to them, for example, in relation to perfection of crypto assets. And this should involve not just legal experts, but also those well-versed in the relevant technology. Thank you very much.
All right, I think we can draw this session to a close. Please join me again in thanking Dora for a wonderful presentation.